May I have your attention, please? It's time for the final countdown. The show starts in 10, 9, 8, 7, 6, 5, 4, 3, 2, 1, go!
Hey, everybody, and welcome to this edition of Doc's Taking on the Mormish. I am your host, Doc, and the clinic is open, and now is your daily dose of reality. So in this episode, first, before I get into that, I do need to apologize. I know I've been kind of hit or miss with new videos, new content. However, real life, coming to the end of the school year for the children, and real life with the new job, been very busy, so I do apologize. But we're going to hit the ground running here. We have a great video for you guys today. So as the video is titled, Mr. Killoran discussing the non-malfeasance, he is back at it again. It is quite interesting listening to him over the past couple weeks. He has come out full force, a lot of new videos. Again, a lot of things he does not understand. So, you know, we've tried to weed out a lot of it, but in this particular video here, you know, the video of the original video is titled "Their Malfeasance Will Bite Them in the Ass," which is quite hilarious because he's going to talk about a few things and we're going to debunk it right away. I'm going to let you guys listen to the first part. He's going to read Article 1, Section 10, Clause 1 of the Constitution. And what he's not telling you is what he's reading deals actually with the states and what their authority is, what they're allowed to do and not allowed to do. He also talks about a quote-unquote title of nobility, which, again, he has not done any further research himself. And as he likes to say, you know, don't believe what other people do and do your own research. Don't take my word for it. And so we're not, because everything that he has brought up has been false. It's out of the old soft sit playbook and it's been debunked 100 times. We're just putting a different spin on it. And, you know, we like giving it our own taste and things. So I'm going to go ahead and get this video up. I want you guys to see this. So let me go ahead and we'll give our nice little, we'll hide our main title here. And there's this video. He's getting to the point now where he's showing more. It's quite interesting. He does have a computer that he'll film. I have recommended to him that he does use StreamYard for his videos. It may help things. He'll be able to share documents into the overlays and stuff. And so here we are. I'm going to let you start. I'm going to let you listen to it. His video is about 19 minutes long. And it's a lot of the typical stuff, but I want you guys to listen to this first part when he reads this. And then what we're going to do is we're going to get a little bit of a history lesson. We're going to talk a little bit more about this. You know, what he's also going to show you is a letter, and I need to get this up for you guys to look at as well. He's going to go over this letter that he got sent from the law director there in Zanesville, city of Zanesville. And it's going to be quite funny what he calls this letter, because no way, shape, or form does it do anything that he's stating that it does. We're going to talk about a few other things as well. We're going to talk about how important things such as a one word in a law could mean, or in a statute. So I'll also put the link to my blog in the description for this, because we have done a full blog post on this and posted some links in there. You see right there, we do have the link to our blog. Check it out. We try to post up there quite regularly, so give that a shot as well. So without further ado, let's go ahead and listen to Mr. Killoran.
So I got another document here that I wanted to show you all. But before I do that, I wanted to read something for you. If you want to pause this for a moment after I give you this citation, so you can look it up yourself and follow along, that's fine. I'm going to read Article 1 of the United States Constitution, Section 10, Clause 1. Now this states, no state shall enter into any treaty, alliance, or confederation, grant letters of marque or reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. Those last two things I want you to pay attention to.
Okay, now real quick, he read it. Now let me give you. I posted a great link called Constitution Annotated, and it's actually from a official government website. And I know, government, got to be careful because they're probably sending us stuff we shouldn't see. But they talk about that the contract clause provides that no state may pass a law impairing the obligation of contracts. And a law in this context may be a statute, constitutional provision, municipality ordinance, or administrative regulation having the force and operation of a statute. Okay. But are judicial decisions within the clause. The abstract principle of the separation of powers, at least until recently, forbade the idea that the courts make law, and the word quote unquote pass in the above clause seemed to confine it to the formal and acknowledged methods of exercise of the lawmaking function. Accordingly, the court has frequently said that the clause does not cover judicial decisions, however erroneous or whatever their effect on existing contract rights. Nevertheless, there are important exceptions to this rule that are set forth below. Now, like I said, this is a really great document. The link's really good. I'll even put it in the description here, and it breaks down the whole law. So let's go ahead. Now, he's called this out. He also talked about titles of nobility. Yep, we had to shoot him down on that as well. Again, we really love this because you can tell he's really, really pulling out all the stops to attempt to prove his point. But he will end up failing in the long run. So let's get back to his video.
Law impairing the obligation of contracts or grant any titles of nobility. So right now we're going to concentrate on the first part there. Law impairing the obligation of contracts. Now, according to the Constitution and according to the established contracts with the public servants of Zanesville, Ohio, they are required by the contract to act. They have a duty to act to protect the populace from issues that might arise, such as noise disturbances, as outlined in a Ohio Revised Code. See, these codes tell them what they are.
Okay, so I'm going to help you real quick because he's going to forget to mention something very important in this. And again, I went over this in my blog, and I actually have the destination or the definition. So I'm going to read this from you. Yes, it's Ohio Revised Code, Section 71549, Preservation of Peace and Protection of Property Noise Ordinance. Okay, now I want you to listen to this because there's a word in there that, in the legal sense, completely destroys anything that he is saying. Now, Section 1 states, any municipality, corporation may prevent. Now, remember, I just emphasized the word may. Okay? Prevent riot, gambling, noise, and disturbance, and indecent and disorderly conduct or assemblage, preserve the peace and good order, and protect the property of the municipal corporation and its inhabitants. Okay? That's Section A. Here's Section B. anytime a noise ordinance of a municipal corporation is violated, but the source of the noise is located outside the borders of that municipal corporation. So say the municipality is the city and the noise is happening out in the county. Okay, those are two different municipalities. You have the city and the county. Those are two different. And an adjoining municipal corporation, the municipal corporation with the ordinance may enforce the ordinance against that source as long as there is a written agreement between the two municipal corporations permitting such enforcement. So, first off, I have done exclusive research on this, trying to see if there's an agreement written between the county of Muskegon, I think it is, or I can't remember it off the top of my head, but the county and the city. There is none to my extent. I've actually written out to the county commissioners and asked. I've reached out to the county prosecutor to see if they could find it. I've reached out to the director of law, Mr. Talbert, as well. I haven't gotten any responses back, and I do keep up on that. Now, I do want to emphasize one thing that he forgets to mention, because he didn't do his research. Now, this is being that, and I have studied criminal justice. I do have a bachelor's and a master's in criminal justice administration, which does force you to study laws and write papers on them as well. That's part of the curriculum. Now, the key word in all of this, in both section A and B, is the word may. Okay? It doesn't say they must. It doesn't say they shall. It says they may, which means they can or they cannot. They can do or do not. They don't have to act on it. Now, that in of itself is a huge point in this. Now, he plans, okay, in a lot of his videos, is to attempt to go to court and get them to pay up or to lien them. And he's talking about a trustee, which I think is funny. So anyways, I went and I looked this up. And this is, this again is from Cornell University. I've also found this in the law dictionary as well. So I'm gonna read this to you. And this is right from the law dictionary there at Cornell University, at Cornell Law. So the word may is an expression of possibility, a permissive choice to act or not, and ordinarily implies some degree of discretion. This contrasts with the word shall, which is generally used to indicate a mandatory provision. Okay? So that in its simple form tells me that I see the word may that says, okay, it's a possibility we have the choice to act on this or not. Doesn't mean it's going to happen. And it also, ordinarily implies that they have discretion on it. Now, here's the thing. The two places he's complaining about the most are Stave Company and Casting Solutions. One is a ironworks forge. They've been there for over 120 years. Okay. Then there's Stave Company. They make barrels and stuff. They've been there for over 80 years. Now, what's funny is he'll sit there and tell you, oh, yeah, they're nestled in these communities, in these residential communities. Well, that's not true. They are, but it's not due to them building there in that community. It's due to the fact that houses were built around that commercially zoned property. Stave Company is out in the county, and it's by the river, which is where you would want to see an ironworks, because the ships can bring in the raw materials they need to forge into whatever parts they're casting. So that makes sense. His whole great theory on this is that they shut everything down and go dead silent at 7, 8 o'clock at night. He also brought up that, they should move. Well, why would two companies that have been in the area, one for over 100 years, another one for almost 100 years, move? Now, I do on my blog have a investigation that I did on the noise, and nowhere, shape, or form Did anybody have any complaints? I even posted it on the Zanesville, Muskegum County Facebook page asking the same question, or these questions about the noise. Everybody's like, look, it's people working. Give it a break. I have other people lived there 45 years, or generational families that have lived in the area where they're like, you don't even notice it. It's not that loud. And I've asked people, can you hear it in your house? No, you can't. I recently got back a reply because I did some investigating myself, and I sent out letters to the residents in this said neighborhood where Mr. Killoran lives. Not one person that I got a letter back from complained about the noise. So again, here we have this person who continues to complain, but he's not getting anywhere. All right, so I digress. Let me get back to what we were talking about. Now, out of the legal dictionary, thefreedictionary.com, for the word may, again, it is the same exact definition. And it says it's a verb, a choice to act or not, or a promise of a possibility, as distinguished from shall, which makes it imperative. In statutes and sometimes in contracts, the word may must be read in context to determine if it means an act is optional or mandatory, for it may be an imperative. The shall, or the same careful analysis, must be made of the word shall. Non-lawyers tend to see the word may and think they have a choice or are excused from complying with some statutory provisions or regulations. So again, may to be permitted, to be at liberty, to have the power. Whenever a statute directs the doing of a thing for the sake of justice or the public good, the word may is the same as shall. For example, 23H, DAC 6 says the sheriff may take bail. That is construed he shall, for he is compellable to do so. The word shall and may in general acts of the legislator or in private constitutions are to be construed imperatively. But the construction of those words indeed depends on circumstance. So again, the way this is read is they may. It doesn't say at all that they have to act on whatever violation he's talking about. So exactly, Pedro, you bring it up perfectly. It's the pig farm argument. Don't buy a house next to a pig farm if you can't stand the smell. These people knew when they built their house there that there was that noise. And they built them anyways. Just like in the city, as more of these modern day homes were being built, which a lot of them were built in the 1950s, the stave company and casting solutions were already there. They were already set up doing their stuff. So let's get back to the video. It's pretty interesting. We'll debunk a lot more of what he's saying too.
Allowed and not allowed to do. These codes do not tell me what I'm not allowed to do or allowed to do.
Actually, they do. You just have to read a little further in the codes when you get into things like riots and other disturbances. Yeah, they kind of do.
They don't pertain to me. If you don't understand.
That's the typical soft sit excuse. It doesn't pertain to me. They're all commercial corporate laws. They don't pertain to me. Well, I hate to tell you, they were written because probably some idiots were having a party. Somebody probably started a riot. Noise from gambling, loud noise from street races or parties. So yeah, they kind of do apply to you. They do.
And that, then I don't know what to tell you by now. There's a separation, and these are commercial codes. This is not the law. So,
okay, again, they're not commercial codes. Codes and statutes are law. They are debated, discussed, voted on, and then signed into law through the legislature. So again, he's wrong. This is what soft sits do. So again, and the MOOPs are the same way. They want to say everything's commercial. It doesn't apply to me. Well, it does apply to you. Go ahead, make a noise disturbance. Go outside and crank your stereo up in the middle of the night. I guarantee you they're coming to get you if you're doing it and people start complaining. That's how it works.
with that being said, I'm going to get into the document here. So, David J. Tarbert was one of the witnesses that had bared false witness against me and claimed that I was causing harm and harassing and so on and so forth in an attempt to cover up their malfeasance.
So what he's talking about is the over 153 times in a 3-month period that he called the non-emergency line of the 911 dispatch switchboard. Now, if you listen to these calls, they are very narcissist. His personality really comes out. He is very abusive verbally. Just the name calling alone, he talks about, well, you're not going to do nothing. So again, it's just constant complaining every single day. Like he expected it to happen like right away because he called in a complaint. That's not how it works. Again, as the law states, that's just Ohio revised statute. Now, when I read the Zanesville city code or law for noise, nowhere does it mention any of this. So again, because it's outside their jurisdiction, because they write codes for the city, not for, even if it's 5 feet past that county line, they can't do anything. That building, that operation is in the county. And if they don't have a written agreement between the city and the county to enforce a noise ordinance, there's nothing to be done. There's nothing that can be done. I do want to say that a gentleman he is mentioning, Mr. Talbert, great guy. When I requested the information that I needed for this, and I will be making sure I have to pull it off my other computer, I will get that information up to you guys so you can start thumbing through it yourself and just see how nuts it is.
Because they were refusing to act, in which, like I had mentioned just a few moments ago, that they have a duty to act according to the contracts. So this is what David J. Tarbert did. Now, keep in mind, this is the quote-unquote law director for Zanesville, Ohio. And, well, I'll just get into the document here. You can see for yourself. So here's the heading here. I'll bring it up. The City of Zanesville, Office of Law Director, has all that information. Let me see if I can get that to focus a little bit better. Okay. So AC address, date, May 6th, 2020. He addressed it to the person, not me. Let's see. In regards to the non-emergency calls, the calls that I was making to the non-emergency line regarding the nuisance disturbance noise that I have evidenced more than enough times, that these incompetent and malfeasant public servants refuse to pay attention to. So this is what David J. Tarbert did. I'm going to read this for you. So it states, Dear Mr. Killoran, which that's not my name, so he misaddressed it anyways. As you may remember, I am the law director for the City of Zanesville. While my office does not typically send out warning letters when we believe a crime has been committed, I know you have devoted much of your life to the service of our country, and I wanted to provide you this well-deserved courtesy. It's patronizing. The Zanesville Police Department,
I don't see any patronizing,
informed me that you made over 153 calls. Let me move this up here. That you made over 153 calls in the past 3 months to the city's non-emergency dispatch line. This number of calls could easily disrupt the concentration and efficiency of our dispatchers, thereby possibly placing our officers and citizens at risk. I must ask that you cease and desist all non-emergency calls to our dispatchers. I assure you, whatever complaints or grievances you may have with the city are better suited for a conversation with your council representative, the mayor, or myself. Now, keep in mind, I've talked to all these people. This is just subterfuge.
So what I'm doing is I found who his council, what ward he lives in. He lives in Ward 1. I have the councilman's email. I do have his address. So I do plan on reaching out to him and just asking some basic questions like, hey, have you discussed this noise issue that Mr. Killoran seems to have since he's had for the last 3 years, he states, what has been your, I guess, suggestions to him if you have spoken to him, or have you not? Mr. Killoran has made some just unlavish claims lately about some of the things that he suffered in jail that happened to him. Now this right here, how he said, well, I've talked to everybody. What's funny is I've listened to some of these conversations because he records them. And I'm still trying to figure out when he spoke with, when he speaks to the mayor, he's very disrespectful. So if I was a mayor, I wouldn't want to do anything for you. But then again, because I'm elected by the people, I would want to at least take a gander into this and find out what's going on. What a lot of people don't realize is with him complaining is there was a lot that was being done for him. So, it's interesting when you hear him talk and say, oh, no one did anything for me. They actually did. They were going to spend money to have this stuff. But yet he said, well, no, you don't need to put that on my property. It should be from the offending property. Well, you are the offending property. You're the one complaining. That's why they need to put it on your property. And you're complaining that you're hearing it in your house. So that's where they're going to take the reading from, the closest offending property, which would be you. You're the only person complaining about this. He turned away every bit of help. And see, again, I don't think he realizes that, because that's going to come and bite him in the ass later. He talks about their malfeasance, but yet here he is. He's turned away help that has been offered. The city was going to spend money. One of the estimates was just almost $7,000. One was just over $5,000. They were going to offer to do this and pay for it. He brought up and he brings it up again. He talks about wastewater treatment plants and how they build things and do stuff like the blower engines. But what was really funny about it was he took an article from Florida, and I can't remember where it was in Florida. He tried to compare it there, and he kind of got shot down. And it was like, no, that's completely different. That's comparing apples to oranges here. So again, he's trying to express his frustration, which I can understand it to a point. But when I watch his videos and he's outside recording the noise, and he does one video where he talks about noise and he makes himself sound like an idiot. I mean, he sounds like an idiot in most of his videos, but the ignorance in what he's saying is his arrogance is so bad that he doesn't understand that what he's saying is wrong. So let's continue.
I guess that's the right word. I truly do not want it to reach this level. Bullshit. But any more non-emergency calls placed by you to our dispatch center could result in charges being filed. Such charges could include, but may not be limited to, disrupting public service, obstructing of official business, or telecommunications harassment. Obviously,
he was charged with telecommunication harassment. For some reason, the prosecutor dropped it. And again, that is a big, big question mark in all of this, why the prosecutor dropped it. I mean, did he think because the minimum sentence, he wouldn't have got the maximum because he's already been in jail? That makes me wonder why the prosecutor dropped that charge in particular. I'm very interested to find out. I'd love to find out. If I could find out who the prosecutor is that tried this case, I would really love to just ask him and say, why'd you drop the charge? You had him. You had 153 counts of telecommunication harassment. I mean, geez. I mean, why would you drop this? So,
if you have a true emergency, please do not hesitate to call 911. However, if you are just calling dispatch to vent your frustrations, I would ask that you find another outlet for those concerns. Otherwise, we will have no choice but to file charges. If you have any questions or concerns, please do not hesitate to contact me. And there you can see he signed it. Now,
well, of course he signed it. He signed his signature to a letter. That's what you do. Now, it's going to be really funny to listen to this because in the next couple minutes, he's going to try to say this letter is a contract because he put his signature on it. Now, I don't know about you, but when you write a formal letter, you usually have your name printed at the bottom and you sign it above it. You're taught that in English. You're taught, that's business. If you've ever taken a business class and a formal letter, a letter to a loan officer or anything like that, that's what you do. I think it's 4 spaces. You type out your name, you print it, and then you sign it. Because that signing it is saying, yes, this is an official document. It's not saying it's a contract. It's saying it's an official document. Now, you could take something out of there and put it in a contract or make that document part of a contract. But then again, the contract has to be agreed upon by both parties. So, yeah, listen to this.
He sent it registered mail. And there's the little green card that got sent back through the return receipt process. You can see there the signature. Somebody else signed this. This was never delivered to me.
So the reason why I think this probably was signed by somebody else, because soft sets, moops, have a tendency to reject mail. They don't want to put their signature on anything. They don't want to sign anything. Unless you do it the way they tell you to do it. And he has a history of this as well, where he was sent things for court and he just sent them back. And he actually missed a court appearance because of this, and it could have ruined his bond. And so, again, I think because they have this issue with him, and he's known for kicking stuff back, that they probably say, hey, go ahead and sign that. We just need to know it was delivered to the house. And that's what that does. Again, the CO3, C19, I'm not sure what that is, or the SB. I mean, I guess you could call the post office and say, hey, what was this? The copy on the side of that right there is just a stamp at the post office. That was his copy that he kept for this, for the card itself. So, yeah, he may have not signed it, but then again, they know that he has a habit of just kicking stuff back to us. So maybe it wasn't that big of a deal. So I'm not quite sure on this piece.
It shows that it was, but clearly this is not my signature. I don't know what this information is. This SB or SL or whatever it says in the signature portion, and then the received by CO3 C19. I have no idea what that is. I didn't write that. I never received this, but regardless.
So what he could have done was he could have called and said, well, who signed for this? I didn't sign for it. He could have called the post office and asked, but he didn't. So again, his fault.
This is what they based the whole, all the charges that they threw at me this recent time through the county court.
No, there's actually documents. I was scanning in all the information that I got through my public records request, and there is literally six or 10 stacks of when he called. It shows the date and timestamp. There's some that are literally 5 minutes apart. Now, that could be because he didn't get through, so he hung up and recalled back. I mean, there's a couple that are 2 or 3 a night. I mean, it's just ongoing. Now, remember, if you listen to any of my other videos with him and you heard the letter, he's a veteran. Now, we all know if you're in the military, you do suffer for some sort of hearing loss. So I do believe he's got tendonitis. I do believe that he probably could be losing certain tones. I can tell you, there's moments when I just sit at my desk and I can hear the ringing in my ear. It does it for about 15 seconds and it goes away. Now, I'm not saying he's not hearing this noise, but if you have to go outside to hear it, and that pond that's right next to you, the animals are the reptiles and the insects and the animals are louder because it's closer to you, and you're calling out that noise that's just barely audible through all that, I think you have a bigger problem with that pond To me, that would be what's disturbing than that noise. That's, again, you're in your house, you don't hear it. So we continue.
This is what it all stemmed from, was this asshat creating a contract which is impairing the already existing contracts. Let me just...
So now he's calling that letter a contract. That letter is not a contract. It does not impair his rights. What he's said is, please stop calling the non-emergency line to vent your frustrations. That's not what it's for. The non-emergency line of 911 is usually for something like, you know, hey, there's a cat stuck in a tree. Or I don't know, kid climbed up on my roof and he can't get down. He's fine. He's not moving. You know, considering to an emergency, yeah, I'm calling because this guy has 3 gunshot wounds to the chest. You know, that's what you look at. And so they're just telling him, you know, hey, you're excessively calling. We're asking you, please don't, or this is what we're going to do. There was no contract involved. No law was created. None of that. So again, he found something which in that Article 1, Section 10, Clause 1 of the Constitution, he didn't read an explanation. He took it for face value instead of reading the explanation of what that means. And as time has progressed, things have changed, definitions have changed, word meanings have changed. So again, he took it for face value instead of saying, hey, you know, let me do some more research to find out exactly what that entails. It says the state can't. There was no contract there created anyways. So again, I'm trying to see where this contract was created.
Restate that here. So law impairing the obligation of contracts. So what he's doing is he's creating a contract that is impairing their duty to act in their favor. So that way they don't have to act. They don't have to address the issues or the concerns of the noise.
No, that's not what that said, because they've already taken your complaint 153 plus times. So what more do you want them to do on that part? You've started the process. You have to give them time. And again, as I read the law, it's may. It's not shall or must. They have a choice to act on that. They don't have to. They don't have to act on that. Again, your house was built after. Your house was built in 1950. I know this because I did some research on the area. The stave company has been there for over 80 plus years. Casting Solution has been there for over 120 years. You're not going to change their day-to-day operation unless half the town starts complaining, because probably more than half the town works for Stave Company. Well, Stave Company is not that big, but Casting Solutions. And people from there do work for Stave Company. It's a line of tax revenue, business revenue for Zanesville and for the county. They're not going to close up doors. The county's not going to do that. They're not going to force a business out unless it's actually causing detrimental harm to the community.
They're just ignoring that altogether. Now, here in the part, this is what really gets me. It says, this number of calls could easily disrupt the concentration and efficiency of our dispatchers. Well, they should have taken it into consideration and maybe addressed the issue sooner.
No, you don't put a time limit on when your non-emergency issue is dealt with. Okay, let me give you a little advice. I come from a family of firefighters and police officers. My father's retired, and I would ask him how his day was, and he's like, "Yeah, we had a couple emergency calls, and then we had some non-emergency calls." And I was like, "Well, what's a non-emergency call?" "Oh, somebody heard a dog barking from halfway down the street, and that person that complained was 2 miles away from the house that had the dog." And that's non-emergency, okay? And yeah, they'll go out and investigate it, and again, they have discretion on that. they can decide, okay, yeah, we'll go take a look at it. I don't have anything pressing. I'm not worrying about an emergency call. Okay, I'll drive out there and take a look. And then they do. They go, they write down information from the person making the complaint. Then they'll investigate. They'll go down a little further down the road. They'll try to figure out where the dog's right here. Okay, I hear him barking. All right, let me talk to the owners. And they'll talk to them and say, hey, what's causing the dog to bark so much, And they just try to find out, because dogs outside bark at just about anything. Birds, other animals, dogs can sense that. So they draw attention to it. That's dogs, And so they'll let them know, say, hey, somebody down the road complained they heard the dog barking a lot. Just want to give you a heads up. And that's that. Okay. One of the officers did investigate this. They sat in the parking lot. Okay. And yeah, they heard the noise. But what more did you want from them? Because again, they have the discretion to act on this per the Ohio Revised Code to act on this. And so how do you expect them, or what do you expect out of them? They're not going to tell a business to stop operating. Let me explain something to you too. If you know anything about ironworks, and during operations, they're melting iron ore. Okay. They're melting, they're mixing, they're pouring. Okay. When the shifts are off and something is breaking, or they have to do maintenance, they do maintenance when there's no shift. Ironworks factories or forges don't shut completely down. There's always something running. Fans, heaters, melters, they're always running. They have to. You know how long it takes to bring one of them up to temperature to melt iron ore? And it's the same thing with the stave company. They're drying out wood. They probably have, if they make barrels, they probably have furnaces going and drying machines going. That's just part of manufacturing. I can tell you, back in the 80s and the boom of the auto industry, they worked 3 shifts. It's just what it is. And yes, there were neighborhoods around those factories, and they heard the cars, they heard the machines. I mean, that's part of it. Pedro, you make a great point. The noise is a pre-existing condition. It's like the smell of a pig farm or the noise of an airport or school. I know he has an elementary school close by. I pulled a demographic of what's by that address. You don't complain about the elementary kids getting out of school at 3:40. But I'm sure that's normal hours for that. Just like when you record a noise at 4:45 in the morning when people are getting up, or that those first few people have walked into the factory and have started working for the day, that's work. You're complaining about people working, which is weird.
This has been going on for well over 3.5 years, since July 2018. I don't recall.
Yes. If you get a chance, go back and listen to some of the videos. Just the noise videos are hilarious. I'm like, what are you trying to hear? And I have pretty good hearing. And I'm like, I put my really expensive noise canceling headphones on and listened. I'm like, what? Okay, you got a pond by your house, because I can hear bullfrogs. I can hear bullfrogs over a noise that's traveling, that you hear. The sound is traveling from its point of origin to you. The bullfrogs are louder. Why wouldn't you complain about the bullfrog? Again, it's weird. But this letter is no way, shape, or form a contract, like he's trying to say it is.
Call the very first date that I had made the first complaint to the police department. However, they should all be very aware that they do have a duty to act. It says very clearly that their duty is stated in Ohio Revised Code 715.49 in sections A and B, where it describes that they have a duty to address noise concerns, disturbances of.
He left out the part. He left out the most important part of both of these sections. The word may. Doesn't say they have to. It says they may. It doesn't say shall. And may and shall are not anywhere in this. So they're not working as an imperative. It says they may. They may. It's pretty much, maybe I will, maybe I won't. And that's what it is. It is not imperative that they act. And due to Section B, because one of these are out in the county, they can't act on anything unless they have a written agreement between the city of Zanesville and the county of Muskegon. Muskegon. It's like Muskegon, but it's Muskegon or something like that. So those two municipalities, those two corporations, they can't do anything unless they have a written agreement to enforce a noise ordinance. That's how that works. You gotta finish the whole thing. You gotta read the whole entire code, law. And yes, this does apply to you as well, Brandon, Mr. Killoran.
The piece, I can't remember the exact terminology off the top of my head, but it states it very clearly in that code. These are the codes that bind them, not me. So,
you know, it's funny. He keeps saying it binds them, not me. It binds you as well, because it says, if you read it, any municipal corporation may prevent riot, gambling, noise, and disturbance, and indecent and disorderly conduct or assemblage, preserve the peace and good order, and protect the property of the municipal corporation and its inhabitants. So that pretty much seems these apply to you too. Like I said, I encourage you to go outside at, 2 a.m. and crank your stereo up all the way. And just keep playing it for 30, 40 minutes. I guarantee you the cops are coming to see you. Guarantee it. And again, if there's no written agreement between the city of Zanesville and the county, they can't act. That's what this says. This is plain as day, folks. I can't. I could beat you. I could beat this into you. And if you still didn't understand it, I wouldn't know how to break it down any further. But this really sits here and it tells you, one, the word may is prevalent in both sections. They may. Doesn't say I have to. It says I may, if I so choose. And then the other one says there has to be a written agreement between both municipalities. So again, you don't understand how this code actually works. You're saying that it demands. No, it doesn't. No, it doesn't. I guarantee you if I went to his video and posted this and said the key word in both A and B is the word may, look up the legal definition of may. Here's 2 links. And then the written agreement between the city and the county. If there isn't one, guess what? The city doesn't have to enforce anything. They can't, actually, because there's no agreement between the two. So you have a double-edged sword problem right there, and you got to pay attention and read. You can't just fly by it and think you found something.
What he's done here is he's created a fraudulent contract, which is impairing their duty to act.
No, it's not impairing their duty to act, and there's no contract. What he said is, please stop calling the non-emergency line, and if you continue to call the non-emergency line to vent your frustrations about your issue, then we may have to file charges. And here's what a few of them might be. That's what it states. That's what it says. That is not a contract. No way, shape, or form is that a contract. And does that limit their ability to act? It doesn't. Nowhere in there does it state that. A letter is not a contract. Again, you read something without following up to get the actual meaning, and then you probably read something on some soft set website, maybe, again, the queen of them out there in Alaska, and so you think this is right. You think there's a contract there. There's not. Plain as day, there's not.
So this is a violation. This is a color of law action depriving me of rights. This is a violation of Title 42, Section 1983 of the U.S. Code.
All right, hold on. Because I went through my documents and I was looking for that because that has to deal with another post I'm going to do with him because he calls out 2 Supreme Court cases and has no idea what those cases mean. So let's talk about this. 42 U.S. Code, subsection 1983, civil action for deprivation of rights. Okay? It says every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to be to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in the action at law, suit, inequality, or other proper proceedings for redress, except that in any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or a declaratory relief was unavailable. For the purposes of this section, any act of Congress applicable exclusively to the District of Columbia shall be considered to be a statute of the District of Columbia. Now, I did some research on this, and basically what this says is if anything would deprive you of rights under the Constitution and the laws of this country, okay, then you have some recourse. Okay, that's what this is. What he just stated does not. There's no deprivation of rights at all. They didn't take any rights away from him. They didn't say he couldn't call 911 if he had a legitimate emergency. They didn't say he couldn't call. Yeah, exactly. He thinks he discovered a thread to tug on. They didn't say you could not call the non-emergency line. They just said you can't call. Please don't call the emergency line, non-emergency line, if you're going to vent. That's not what it's for. Those ladies are trained to take the complaints, take the reports, and pass them along, whether it's a non-emergency or an emergency. Now, if you start calling 45 times in a day and you're taking their time away from the real emergencies, then yes, you're degrading the efficiency of those dispatchers, and you could cause potential error because they're dealing with you constantly calling about the same thing over and over several times a day or night when you've already done it once and that's all you have to do. Now, why you didn't go talk to the police after that, or go to the stave company, or go to the casting solutions and talk to them directly is still beyond me, because I honestly believe, again, as you're a soft sit, you're looking for a way to think you're going to get a payday. So again, back to 42 U.S. Code 1983, civil actions for deprivation of rights. There's no deprivation of rights. That does not fit this at all. He's still subject to the laws of this country, the Constitution, the laws of the federal government, and the law of the state through their state constitution and state laws, codes, statutes. Remember, code and statutes are laws. So again, you need to read this and get the definition, Mr. Killoran, in the explanation. I would highly recommend you find someone at Cornell Law or Yale Law that can explain these things to you so you have a better understanding. Because I think if you explain to them what you're trying to do with this, they would come back and say, no, actually, you don't have a leg to stand on. Here's what that actually means. I think your videos would be great classwork for first-year students at Yale Law. I mean, that it's ridiculous. So let's continue.
Not to mention a violation of the Constitution. So
there was no violation of the Constitution anywhere in this. Again, he has still not, he brought up that article, but again, after we read through it and read the explanation, the explanation of what that article means, and then we go back and we look at the Ohio Revised Code and see how he didn't really read that all the way or understand what certain key words in those codes mean, and the definition of those, he has nothing to stand on. This is going to be hilarious. I'm really waiting for him to do this whole I'm filing a federal lawsuit, because the second that they see this, a federal prosecutor or the people that are trying to sue, pardon me, which is the city of Zanesville and certain individuals, they're going to laugh at this. They're like, are you serious? You have no leg to stand on. We're going to walk right in the court and say, Your Honor, we want this dismissed because there's no evidence. There's nothing. He has nothing to stand on. He's provided no evidence whatsoever that proves any of what he's stating or why he's brought his case. And then you're going to spend all that money filing all that paperwork and just get shot down again. So let's continue.
I wanted to show you all this document here because this is how David J. Tarbert operates. He doesn't understand that he has a duty to act. He should have addressed the disturbances in the courts. He should have been the...
No, actually, he shouldn't have. No, that's not his job. That's not his job. Now, you could say the chief of police, it would be his job, but it's not this gentleman's job at all. He is, from what I gathered, he's kind of like the legal counsel for the city. He looks out for the city. However, the chief of police would have been the one that would have acted on this and decided, again, because they have discretion. Are we going to... Now, he's the only one complaining about this, so at this point, we're good. We're not going to worry about it anymore.
One, to file documents in the court against these business operators to force them to cease and desist their production in the middle of the night.
Again, you hear what he just said. Oh, he should have filed this to cease and desist their operations. No. Again, they have discretion. According to the law, they may or may not act on it. And he chose not to because, you can listen to the masses or you can listen to the minority. And, again, maybe, I don't know, maybe somebody brought it to their attention and said, hey, explain why you can't, explain what runs at night when you're not in operation, why it runs at night, and what would happen if it was shut down. I think that would be the proper way, and it was probably already done. Same thing with those dryers over in Stave Company. They got to keep those things going. If they turn those off, they're losing, those barrels would be ruined. So, or wood be ruined in general, and that's a cost to the company. And I'm sorry, the cost of that far outweighs one person complaining. I've looked. Okay, I've searched YouTube. I've searched the internet for articles, for complaints. I've reached out to the actual companies asking, how many noise complaints have you had in the last, 5 years? And I get 0. If you have a problem with a company, you call a company. You don't try to dodge around it and force somebody else to go do it for you because you don't want to take the time to have that conversation. And no, that wouldn't have been Mr. Tauber's job to file suit or anything against the courts because, again, I think it would have been where it probably would have got brought up to the companies. They probably would have hired a sound company to go out and take readings at that location, at his location, Mr. Killoran's, and been like, look, this is the decibel reading during the day. This is the decibel reading during the night. And if we look at another a city in Ohio, which I look, they have a pretty responsible noise ordinance, and it's nowhere near that. And that's outside. So let me go in your house and take these noise readings, which would then again be much less than what they were outside.
Which is a violation of these codes and statutes that actually apply to corporations. Because if you look up the word person in the definition.
So let's look up. That's his favorite thing to bring up. Let's look up the definition of person. So right here, I have person, a human being regarded as an individual. And there's other ones. Let's go to, let's see. Here's the legal definition. Okay. Again, legal dictionary, thefreedictionary.com. Person. Here we go. So they have here, in general use, a human being by statute. However, the term can include firms, labor organizations, partnerships, associations, corporations, legal representatives, trustees in bankruptcy, or receivers. A corporation is a person, for purpose of the constitutional guarantees of equal protection of laws and due process of laws. That is the reason why a corporation, quote unquote, is a person. Okay. Foreign governments otherwise eligible to sue the United States courts are persons entitled to institute a suit for trouble, damages for alleged antitrust violations under the Clayton Act. Illegitimate children are persons within the meaning of the Equal Protection Clause of the 14th Amendment to the Constitution. The phrase interested person refers to heirs, divorcees, children, spouses, creditors, beneficiaries, and any other having a property right in or a claim against a trust estate or the estate of a descendant, ward, or protected person. It also refers to personal representatives and to fiduciaries. Now, we have another definition right here where person is a noun, and the very first definition is a human being. Here's another one by the Collins Dictionary of Law. Person, the object of legal rights. There are two kinds of legal person: human beings and artificial persons, such as corporations. So again, because he doesn't read everything, he only reads what sounds good and that he can cherry pick to fit his narrative. He doesn't read everything. Another one we have here is person. The word is applied to men, women, and children who are called natural persons. In law, man and person are not exactly synonymous terms. Any human being is a man, whether he be a member of society or not, whatever may be the rank he holds, or whatever may be his age, sex, and so on. A person is a man considered according to the rank he holds in society, with all rights to which the place he holds entitles him and the duties which is imposed. This was first Bobbin insert N137. So again, it is a human being. It is the law. It is a noun. Person has several different definitions to it, but he doesn't recognize that because that'll kill everything that he's trying to do.
It states very clearly that it's corporations, companies, that sort of thing. So this is a perversion in a way to not only harass and intimidate me and force me to be silent, but potentially profit off of the fraud.
So one, they didn't force him to be silent, obviously. They weren't trying to intimidate you. They just told you what would happen if you continued the same behavior, the same action. There's no fraud. There's no scheme to make a profit. None of that. So please continue, Mr. Killoran. Explain how there is no malfeasance.
Because of the bonds that are created and sold in the open market off of the charges.
Also, there are no bonds that are created and sold in the open market. When you commit a crime and you go in front of a judge or a magistrate, they can set your bond. All that is to make sure you come back to court. And if you come back to court and follow the orders of the judge, guess what? You get your money back. That's how that works. Nothing's being sold on the open market. To this day, I have not seen anything related to somebody being arrested and a bond created and sold on the open market. So again, more soft sit BS, more moot BS. None of that is true. It's all been debunked.
That are created fraudulently. Not to mention that all of the police officers and detectives who were involved in this whole situation failed miserably at being aware of the fact that I already have existing contracts with the city outlining their malfeasance and fraud. And
so what he's talking about in contracts, like I said before, he wrote a bunch of soft sit nonsense, tried to say silence is acquiesce, that it enforces the contracts and puts them into effect. Well, that's not true. That's not how it works. Your paperwork wasn't filed the proper way to begin with. And they are, these so-called contracts are in the document for the court case, in the documents for the court cases he was in. They're off the wall. I mean, I will take time and we will go over one so you can see what I'm talking about. But they're not contracts. They weren't signed and agreed upon by both parties. He thinks just because he put in there, oh, if you don't respond by this day, the contracts are in effect. That's not going to happen because, again, they're not legal contracts. So acquiesce doesn't mean what he thinks it means. He thinks that if you don't respond, well, the contract's enforced. Well, it's not. They haven't been, and you have no legal leg to stand on. I'm still waiting. I'm very interested to see what happens throughout 2022. This whole thing, he talks about this trustee going in and putting liens and seizing people's property and their bank accounts and their house and all this. I'm so waiting to see this happen and just watch him fall miserably.
They have, in fact, by going through this whole process, have now added extra charges to their already laundry list of charges that I have and damages that I've outlined. And so I'll leave it at that. So the other part of the clause that I had read just a few moments ago talked about titles of nobility. Now, we all know, well, at least you should, if you read the Constitution, that titles of nobility are forbidden. They're prohibited. They're not allowed for a reason, but I'm not going to get into that. But it states very clearly and specifically that titles of nobility are not allowed. They're not authorized. Well, what is a title of nobility? Well, if any of you have dealt with attorneys or, say, people like Donald Mason, you would realize that they carry a title. They add a title to the end of their name. They claim that it was given to them by the state. And what that title is, they call it Esquire. Now, what Esquire actually is.
So hold off. Before he goes on his bullshit rant, which is what it'll be here, let me give you a little insight of Esquire. Now, yes, back in the day, it was a title given to the next son in line. So say if his brother was a knight, you would have Esquire and a squire. Okay. You took care of the equipment, you trained them, you practiced with them. That's what it was. But let me explain what this is here. Okay. Let's explain this. So I have a US version. This comes from lawschool.com. What does Esquire mean? And then I have another one here, which has the more traditional meaning of where it came from. So the title Esquire, often abbreviated ESQ, is a term typically used in the United States to designate a person who may practice law. The title Esquire, which may apply to a man or a woman, goes after the person's name. So I could say, hello, this is Joshua Craven Esquire. Okay. This modern meaning employed in the United States is very different from the original meaning of the word esquire, which originally meant an apprentice to a knight aspiring to noble rank. It is a cognate of squire. In America, where noble titles are constitutionally forbidden, the designation is usually a professional one or one of esteem. Though usually used for lawyers, esquire is occasionally used as a formal address for a poet or an artist. So let's see. So the only time you use the title Esquire is when you're addressing others, never yourself. Even lawyers, though generally a pretentious bunch, would consider it way over the top if you walked up to them at a meeting and said, "Hi, I'm Joshua Craven Esquire." If you are introducing yourself and you feel it is necessary to communicate that you're a lawyer, it's sufficient to say, "Hey, I'm Josh Craven, attorney," or "I'm Josh Craven, attorney at law." Make sure the person who you address as Esquire is in fact a licensed attorney. Your classmates at law school aren't Esquires yet. They have to pass the bar and be sworn in first. If the term is used all in speech, it is probably best confined to a very formal context and generally only when introducing a person. It would sound foolish to keep referring to someone as an Esquire several times throughout a conversation. The safest approach is probably not to use Esquire in a spoken form at all. The term is most often employed as an honorific used in written communication. Here, things can get a little complicated when writing to another lawyer. You would generally use Esquire or ESQ in their physical address. However, you would still address them as Mr. or Mrs. following the salutations. So again, what he's trying to get at is that we're using a royal term. Now here, again, I have the United Kingdom one. It says Esquire is usually a courtesy title. In the United Kingdom, Esquire historically was a title of respect accorded to men of higher social rank, particularly members of the landed gentry above the rank of gentleman and below the rank of knight. Some sources cite that the title was bestowed on candidates for knighthood in England and even used with respect to other dignitaries such as justices of the peace, sheriffs, and sergeants. So we see here that no one is taking a title of nobility. It is just a designation used by people who may practice law. So again, it doesn't at all, mean what he's trying to say it means. Okay, and yes, some states can grant that title. That is very possible. So again, I posted the link in the blog that you can read what I found. So he's trying to say that they're taking a title of nobility, which they are not. So again, he fails miserably because he did not follow his own words and do the research. He just took it for face value. Again, this is what soft sits do. They're horrible at research. Obviously, Anna von Wright and all those people have already done it for them, so they just cherry pick what they want.
It's the equivalent of a squire, like in medieval times or whatever you want to say, with under a monarchy where you have knights and jesters and all that kind of stuff. Well, a squire is basically one step under a knight, and so these people are taking this British title of nobility, Esquire, and attempting to set themselves apart as if they are better than the rest of us, as if they have.
Again, all his claims 100% completely false after what I just read. Again, soft sits are known for this. They cherry pick what they want to make their argument sound good. They don't do any research because everything they use has been used 100 times and has failed 100 times.
Have more rights than the rest of us because they carry this title, but this title is unconstitutional. It's in violation.
No, this title, how it's used here in the United States, is not unconstitutional because nobody is bestowing the title on them. Okay? There's not a queen bestowing a title on them. Okay? So again, he is wrong. He is completely wrong in this. You can't be any wronger, man. I mean, shit. I don't know how you don't do the research at all.
Of the Constitution, these people are directly and blatantly violating the Constitution that they should have sworn oaths to uphold and follow. So
if this was such a huge issue, it would have been brought up way before the soft set movement started.
They are spitting in the eye of the contracts and the charters that were created that bind them, that tell them what they can and can't do, but they don't care. They don't care because there's no accountability. So just keep that in mind. When these people do and say things, they are not acting in our best interest. They are acting in the best interest of the corporation. They are acting in the best interest of themselves. And unfortunately, many, many times, we the people lose on that front. So I just want you all to be aware of this. These people are blatantly violating the laws, the actual laws. As you read there, or as you heard me read, I should say, in that letter from David J. Tarbert, he mentions, let's see, where was it here? He mentioned something about a crime being committed. Where was it at?
Basically, what he's talking about is he mentioned that, if you continue on this, we can file charges of telecommunications harassment. We can file charges of, I think the other one was interfering with official business and other charges. He didn't make a threat. He just told you that if you continue this behavior, this is what can happen. He laid out the consequences for you.
Give me 1 second here. I got to find the section.
So at this point, he's going to continue on. He's going to find his little section and go over. But again, he's going to be wrong. Now, as you saw, we took a little bit longer than I thought we were going to. He is wrong in everything that he stated. We went through this. We read U.S. 42 Code, subsection 1983. None of this fits in that. We went over Ohio Revised Code 17. I have it here. I was just looking at it. 715-49 talked about how important that word may is in there. And then we also talked about that if there's no written agreement, then there's nothing that can be done. You have to have that written agreement. And I believe one of the officers even told him that. He's like, look, I can't do nothing. That's in the county, and he expected them to violate that municipality and just go and say, well, you can do this to him. Well, no, he can't. There's no agreement. Okay. And even in the Zanesville Code for noise, there's nothing that states a business can't operate during, non-wake hours, I guess. Exactly. The letter is very much like that, Pedro. You are absolutely correct. It is the warning before being trespassed. And, that's the sad part is SOV sits are face readers. They don't dig deeper. But that's what I enjoy doing. So that's why I do these videos. And yes, I have been focused on Mr. Killoran for a while. And the reason for is he's producing videos at a very fast rate. So, when I saw it this morning, I was like, ooh, what'd he do? And, reading it, I was just like, oh my God, whatever, dude. We talked about everything he talked about and actually got the explanation to Article 1, Section 10, Clause 1. Talking about contracts, talking about titles of nobility, he's not reading any further because, again, as he reads further, if he is, he's finding out that it's destroying his argument. And again, that's what these people do. They don't do any further research than the face research. And again, because this group searches so much on soft sit stuff and these old laws that don't pertain anymore, they've been pretty much eradicated due to the changing times. They keep pumping this stuff to the top of their search engine, and that's what they keep going to. Excuse me. So again, we went through everything. I've thought about posting on his site and being, look, man, I think you need to read that again. You're missing a key word here, and the key word is may. Doesn't state they have to. So, again, it is what it is. We do have another video queued up. And again, because I'm going to try to get back in and doing content on a regular, I'm probably going to go and do, live videos Tuesdays and Thursday nights, maybe do, Doc's Drive on Monday, Wednesday, and Friday when I'm driving into work or driving home. So, that kind of stuff. That way you guys get some fresh content every week. But we do have some other videos. There is another video we are going to be doing this week. He does bring up, it's pretty interesting. He brings up 2 cases, and what he's trying to, I think, do is talk about how the rights and such don't apply. And so we'll definitely go over that. But the 2 cases we're going to be, reviewing, and I do have the breakdown and what they mean and what they're for. One of them is Executors of Cruden versus Neely in the North Carolina Superior Courts of Law and Equity of North Carolina. This was back in May of 1796 is when this case was done. And there's a explanation to this as well, which is really nice because it is kind of dry. The other one he brings up too is Penn Hollow versus Donay's Administrators, 3 U.S. 54, 1795 in the U.S. Supreme Court. We're going to be talking about both these because it's so funny to listen to how he calls these out. He calls out one section, but he doesn't talk about what the case was actually about. And again, soft sits like the cherry pick. What makes it sound good? I will tell you the other thing. For the link that I have posted on this article from the Constitution, it's really great. There's a lot of great case law that they call out and cite. So again, just a lot of great stuff. I think there's 79 different sources that they used and they cite in this. So the link is in my blog as well, and I'll post that in the description to this video. But again, there's nothing happening there. He's make-believing, like it was said earlier in the chat. He found a string that he thinks he can tug on. But I think what he's going to realize is if this does go to federal court, like he was talking, I think, those judges are going to go up there and they're going to pull that and say, did you actually read the law? Do you see where the word may is in this? That they don't have to. Also, it says they have to have a written agreement. Is there a written agreement between the county and the city? If not, nothing can be done by the city PD because they don't have authority to act in this provision in the county. So, it'll be quite interesting. I'm waiting to see. I'm dying to see the trustee that he has. I really think it's his sister. So, and that'll be interesting. But again, it is what it is. I appreciate the fact that he puts out these videos. It gives me content, something different. We see a lot of soft sit videos dealing with traffic stops. We see a lot of more videos dealing with the same thing. So I'm trying to do something a little different. Yeah, my videos are a little longer, but hey, it ends up being fun. So again, everybody, I appreciate Pedro. Thank you for coming in. Thank you to everybody that will watch my video later. I do go back and respond to those comments that you guys leave. Please make sure to like, comment, and subscribe. Let me know what you think. I love reading your guys' comments on this stuff. And be looking for the next videos. They are coming out. Let's see. Tomorrow is Thursday. I did a video this evening, so I may do another one. There's a couple short ones that I want to do on Mr. Killoran where he's trying to, in a way, call out the mayor, Donald Mason. And again, he's not talking to the right person. So I'm dying to find out because I think there's going to be a third video. I'm hoping it comes out tomorrow or at least Friday to see what he's trying to do. It's like he's trying to put him on notice or something, but really not putting him on notice because it's really not Donald Mason's job. It's not the mayor's job to look into this for him. He's the mayor. He's got more things to worry about than little Mr. Killoran. So again, thanks a lot, everybody. I appreciate everybody tuning in and watching my videos. And again, we'll be back. The clinic is closed. Doc's out of here. Have a great night, everybody. Doc's out.